judges will attempt to get to those questions and answer them as we go along. And finally, on behalf of WDTL and the board, we would really like to thank Judge Keenan and Judge Williams for being here today and talking about this topic. And I will turn it over to you to introduce yourselves so that we can maximize our time with you here today.
I'm Dave Keenan.
Matt Williams. Dave's up north at downtown Seattle. I'm here at the MRJC. And we are, I think, the two record holders for the number of fully remote jury trials. I'm actually have a jury in deliberation on my third fully virtual jury trial. And Judge Keenan is one of the court's leaders in the development of the processes, the training, but also just how we handle this new world that we've entered, which is virtual jury trials.
Well, that's really kind. Judge Williams and I have presented a lot on this topic, along with a lot of our colleagues, not just locally, but around the state. I'm going to share my screen with you. I'm on the bench right now in my courtroom, and I think Judge Williams is in his chambers down at the Mailing Regional Justice Center. I've been on Zoom all day. Judge Williams has done a lot of Zoom, all Zoom jury trials. I had one that I finished up last month where I spent a total of about 65 hours on Zoom over the course of the trial. The jury was on for closer to 80 hours. And I picked a number of juries over Zoom, but this is not original work. I mean, Judge Williams and I would be the first ones to say that so much of the training that we've done and the materials that we've helped develop have been in concert with a lot of people around the courts. And so when we present this material, there's no pride in authorship. We really, I think, owe a lot to the colleagues that we worked with on this stuff. So I'm going to do about half of this slide deck, and then we'll switch over to Judge Williams. So the topics that I'm going to address are pretrial and jury selection, considerations when ordering a remote jury trial, electronic evidence, and remote procedures. I won't really get into, and Judge Williams won't get into much how electronic exhibits are handled in trial. That's kind of a separate presentation, but we'll touch on it. Jury selection and jury management, and we've got in parentheses that this might stick around, and the reason is, you know, this isn't a King County specific presentation, but Judge Williams and I do work in King County Superior Court. And the Superior Court here, at least, has ordered that that civil trials, in-person civil trials, are suspended through March. So we'll see what happens at that time if we go back to in-person civil jury trials, for example, at Meydenbauer Center. But it could very well be that at least jury selection over Zoom sticks around for a long time. I think I can speak for a lot of my colleagues when I say that we found it to be a pretty good experience, and I think a lot of the lawyers have as well. We'll talk a little bit about the electronic questionnaire experience and how at least we use that, how Judge Williams and I use that. And then Judge Williams is going to talk about the trial, the thing, opening instructions, the virtual jury room, which is just a Zoom breakout room, the virtual visual trial, handling juror questions. This is a question that we hear a lot, is how do you deal in a civil trial with juror questions over Zoom? And as Judge Williams will probably tell you, there are a lot of ways to skin that cat. Handling electronic exhibits during trial, deliberations and the verdict. And again, there are different ways that courts may handle that, whether it be using Microsoft Forms or something else, but Judge Williams will talk with you about all of those things. So as I said a moment ago, we work in King County. This is not a King County presentation. Judge Williams and I are not presenting on behalf of the county. We did record last week with our wonderful civil chief here in King County, Judge Cahan, and our awesome colleague, Judge Phelps, a series of 4 training videos for lawyers and parties on all Zoom jury trials, and you can expect to see those on the King County website specific to King County practices very soon. We'd encourage you to visit the King County site. There's a lot of good material on there that is specific to King County, but probably would apply to practices in other jurisdictions as well. WSAJ got a similar presentation, and we just say that in fairness. You are all our favorite bar associations. I have here put the questions in chat, but please put them in Q&A, as Aaron said a few minutes ago. Don't put them in the chat, put them in the Q&A. So let's talk about pretrial. Some big things that your judge may cover with you, but in any event, you want to make sure that you cover with your judge is first, what's the trial format? And we ask that because there may be different combinations of Zoom or some other technology that you're going to use along with in person. Right now, at least in King County, if you're going to have a civil jury trial, the entire thing is going to be on Zoom, although it could be that the parties object and the court doesn't order a Zoom trial and it just gets continued. It could be, as an example, we had a criminal trial here in King County that our colleague Judge Richardson did last month, where the jury was on Zoom, but the parties were in person. Criminal is a different thing, right? In terms of what the law applies, and there's a different emergency order in King County right now that that says that in-person criminal trials, jury trials, could resume as early as next month, although with Zoom jury selection. Or it could be some other combination. I know that when we were doing in-person jury trials at Maidenbauer Center, but picking juries over Zoom, in one case, I had the lawyers come in person in my courtroom, masked and socially distanced, even though we were picking the jury over Zoom. So talk with your judge about what combination is going to work in terms of what the health requirements are and what the technology needs are. So you want to talk about the format. What findings and conclusions might the judge need to make regarding the trial format? And we have that in here because it could be that both sides oppose a Zoom trial, in which case, at least in King County, you're probably going to get a continuance. But if one side opposes, and I've had this happen, and I think others of our colleagues have as well, then the judge is going to need to decide, am I going to order an all Zoom jury trial over a party's objections or not? And if so, there are laws and facts that'll apply, and there are orders floating around out there. Certainly the judges have access to them, and some of you as attorneys might have seen them as well. What's the evidence format? Right now, at least in King County, we're pretty much doing everything electronically. So the clerk's office here in King County uses an application called SureFile. In some cases, everything is getting uploaded electronically, but hard copies are being sent to the court and to the parties, or it could be some combination. And in particular, Judge Williams will probably talk a little bit about, well, what do you do? What's the original? How do you get an exhibit in front of a witness? And so we can talk about all of those things. Jury selection, timing, and information sharing. At least here in King, we're using electronic questionnaires over Microsoft Forms. All the credit for that, I think, really goes to Judge Williams. He's done an excellent job on that, and it's been I found it to be a great process. How's the court going to get you the responses from the jurors that are being surveyed in advance? When are the Zoom voir dire panels going to be? Is it going to be on the first day of trial, like an in-person voir dire or something else? And then just share with your judge any anxiety you have. A question I get a lot is, well, how do you prevent people from cheating? Aren't counsel going to be off camera coaching their witnesses? My answer to that is always that this is still trial and the rules still apply. And people could cheat before, and if they were going to cheat before, they may cheat now, but really don't think it's much of an issue, frankly. Some important procedural questions. The way I think about this, and I encourage others to think about it, is before trial, think about everything you do in a trial and how it's different on Zoom. I know that sounds like a simple sort of schema or framework to employ, but that's how I think about it. I go through every phase of the trial and I think, how do we need to somehow replicate this to the extent that we can over Zoom? What do we need? What do you need to do if a matter needs to be taken up outside of the presence of the jury? You just send them to the breakout room, which is what we do. Where do witnesses go? In the Zoom waiting room. How do you display evidence? There are a lot of options there. Screen sharing is the preferred option, but how you screen share and from what application you screen share, there are a lot of options there. What do you do about illustrative exhibits? And this question comes up a lot. Just and Matt, or I should, sorry, not Matt, Judge Williams, Judge Williams, to all of you out there in TV land, Judge Williams will talk with you about, for example, how do you deal with a deposition, which would normally be unsealed in an envelope here in court in an in-person trial? It's a question we get a lot. What do you do about impeachment exhibits, which aren't going to be necessarily created or shared in advance? Those are all really good questions, and we'll talk about all of that. So maybe we'll just stop there. Judge Williams, is there anything coming up in the Q&A or anything that you think that we need to address right now? I can't hear you, Judge Williams. You're on mute. Are you doing that on purpose to demonstrate?
The most common phrase in today's court environment. And let me also just say that the technology issues are going to arise. It's okay. We're going to get through it together. So just right now, as an example, I was on mute. I was also having a slight technology issue, juggling a couple things. We do have a question, and that is, are jurors required to keep their cameras on? Yes. They are. Absolutely.
And we'll talk about that, but that's a fantastic question.
And there's also the question about cheating. I'm going to talk about that when we get to witness prep. And there's also the question about publication of exhibits, which again, we're going to talk about that a little bit later.
Thanks, Judge Williams. So this is an example of a very King County specific example about ShareFile, which is the application that the clerk's office has been using for a while here in King County. And we started using it last year for remote trials, for electronic exhibit handling. ShareFile is, for those of you who practice in King County, it's like a competitor to Dropbox. It's a Citrix product. It's just a shared space where you can upload and download files. We found that it works pretty well. If you're practicing here in King County, just know that if you go to the clerk's office website, or if you just go to the Superior Court website and link from there, there's all kinds of instructions on there about ShareFile, including a helpful video that the clerk's office has made. But from jurisdiction to jurisdiction, I know it's going to vary. So let's talk about initial jury selection. This could take place, at least what we're doing here in King County, before your trial date, using an electronic questionnaire sent to prospective jurors. One thing I want to impress upon you is that whatever jurisdiction you are in, we can speak from experience here in King County, there's a lot going on behind the scenes. I was in a sort of a focus group meeting last year with our bailiff that I work with and some other judges and bailiffs. And the one piece of feedback we had for our colleagues was that the workload in terms of juror management for the judge and the bailiff has increased substantially because of this process. I think it's a process that works well, but be patient, maybe more patient with the judge and the bailiff, because we're downloading spreadsheets, working a lot in Excel where we might not normally have been. The bailiff in particular, where they might not have had any pretrial contact with prospective jurors at all over email, because it was all handled by jury services, at least in King County. They're corresponding with dozens and maybe 100 or more prospective jurors. So be patient with the bailiffs, please. They're doing just a fantastic job. So what we're asking for typically is just like in any other civil case, neutral statement of the case, where before you might have proposed some questions to be asked to the prospective jurors. Now, at least here in King County, we're saying we're going to send an electronic questionnaire. What case-specific questions do you have? We'll put them in the electronic questionnaire. No different than any other jury trial in that respect. The only difference is this is all taking place online. So let me just give you a few screenshot examples. Here's some screenshots of what the questionnaire might look like in King County that we send out, and I credit Judge Williams for all the work that he's done on this. The jurors get a link over email, and it is sent out, at least in many courts. I know in the court that I work in, it's sent out by the bailiff And we ask a lot of things, but there's a lot of technology access questions. And we get this question a lot. What do you do about jurors who don't have technology access? So we're trying to figure out, do they have a device that they can see us over and hear us over, and that we can see them over and hear them over? Could be a tablet, could be a laptop. Maybe Judge Williams could talk a little bit about whether phones work. I know that it's not preferred, but I talked with Judge Zilli, federal judge, who did the first ever federal all Zoom jury trial, and he found out at the end that a juror had been using the phone the whole time and found it to be a good experience. And we want to know, not only do you have the hardware, but do you have the software? In other words, can you load Zoom onto your whatever hardware you're using? Do you have the internet bandwidth? And then finally, do you have the technology fluency? Are you going to be able to use Zoom? Even if you have the hardware, you have the software, you have the bandwidth, do you know how to use it? In King County, we have space in the Seattle courthouse and the Kent courthouse for jurors, prospective jurors, to come in a socially distanced space and access devices if they don't have something at home. This is going to vary from jurisdiction to jurisdiction. I think I know in the federal court here in the Western District, they're making devices available along with hotspots available for checkout. And then we put hardship questions in the questionnaire, and then any case-specific questions that you might ask, assuming that the judge approves of them. So this is, again, be patient with the bailiffs. They're sending out, like this is a screenshot of an email that the bailiff that I work with would send out, and they might send out 100 of these. So understand how much work the bailiffs are doing, the court is doing behind the scenes. And at least in terms of what we download, this is a screenshot of part of some of the responses that I would download in Excel from an electronic questionnaire we'd send out, and multiply that. You see I've got 16 lines in there, but think I might have 100 responses. And also there are several more columns than the ones that are being shown here. And you get some sense of the amount of behind the scenes work that the court is doing. Let me just stop there. Judge Williams, any Q&A that we should stop and address?
Most of the questions that are coming in relate to the conduct of the trial. There's been some great questions about introducing your client to the jury, whether or not your client is on screen. And most of our judges will allow, and in fact, actually, some of us really strongly want your client to have their video on the entire time, so that the jury can bond with them. And our experience has been, and certainly mine, as in the 3 trials that I've done, the jurors really bond with the lawyers. This is a much more intimate experience. They bond with them during voir dire, they bond with the clients, and because they're watching and seeing you and your client kind of in your native environment, just seeing them in theirs. So there's some other questions coming up about voir dire, specifically one about how many jurors are on the screen.
We'll get there.
And the answer to that, of course, is it depends if you're on speaker view, well, the person that's speaking. But if you're on gallery view, all of them that are in the panel. And I know Judge Keenan.
We'll get to that in a second. Yeah. So again, behind the scenes, we're emailing jurors. We're emailing jurors multiple times. We're emailing them initially saying, answer this questionnaire. And then if they're still in the mix after the questionnaire, and think of that electronic questionnaire as it's Monday morning, you're in person here in a courtroom. 50 jurors have been summoned up and they're now sitting on the benches. And I'm starting my spiel and asking my general questions about hardships and other things. That's what that electronic questionnaire is. And then I've excused a few folks on hardship or for other reasons. And now this next email that we're sending out is, you're going to continue in the process. And you're going to get questioned, which means you're going to get questioned by the lawyers. So every court is going to handle this differently. At least the way I've been doing it is I'll send the lawyers a schedule saying, these are all the panels. Here are the scrubbed spreadsheet responses to the questions that have been asked of the prospective jurors. And it would be just as if you were in the courtroom here and I was asking my general questions and you were furiously writing down juror numbers, noting how they responded, except in this case, you can probably have more information and you might have more time. And you don't have to scribble as furiously. Practice is going to vary from court to court, but I think on balance, the Zoom voir dire experience, at least in King County, I think yields probably more information for counsel, and what you might lose. And I hear a lot, well, Judge, I'm not going to be able to see the body language when I'm here in court. And like, I don't know. As a judge, I don't know how much you actually get from body language, but you could certainly get a lot from the facial expressions you see on Zoom. So getting to the question that Judge Williams was just talking about a moment ago, in terms of what you're going to see on screen during Zoom voir dire. So I've found that about, I usually do these in panels of 18, which is about the most I think that you want to have on a screen at one time in terms of keeping track of everybody. A group of 50 certainly doesn't work very well because they would bleed over to multiple screens. So I've been doing these in groups of 18. You know, the latest versions of Zoom allow the host to rearrange the tiles however they want, and then to release that order to everybody else that's watching. So what's happening, at least for me, is I'm renaming the jurors by juror number so that you would refer to them by juror number just as you would in person. And then I'm arranging the tiles on the screen so that they're in order by juror number. You can kind of see that in that first photo, first screenshot, where it's juror 1, juror 7, juror 10, juror 11. So it's in numerical order. Again, the practice may vary from judge to judge. And then ultimately, I'm hiding the non-video participants and releasing my video order to everybody else. So what you should see, depending on how the judge is doing it, is just jurors who have their video enabled, and maybe counsel and the parties, and that's it. And then finally, again, check in with your judge how they want to do things. I know that I tell the lawyers, this is just like in-person voir dire. Make your challenges for cause as you develop them. If you have a challenge that needs to be taken up outside of the presence of the jury, such as a GR 37 challenge or a Batson challenge, anything that needs to be taken up outside of the presence of the jury, let your judge know. And the judge can decide where they want to put the jurors. What I would do, and I would imagine what Judge Williams would do, is maybe put the jurors in a breakout room while that's addressed, although there are different ways to get at that as well. And then you got to figure out how you're going to keep track of everybody. We just use, at least in my court, seating charts. And before we go to peremptory challenges, we send out a final seating chart so that you have a visual, although I'm sure you're keeping notes, so that you have a visual knowing who's in that virtual jury box and then who's in the gallery, so you figure out how you want to exercise your challenges. So I'm going to stop sharing my screen and turn it over to Judge Williams. And Judge Williams, were there any other Q&As that we should address before we move on?
Well, let's see. I think that one of the questions that came in is the fact that we're using Microsoft products, Office, Excel. We're using, which is how we transmit the questionnaires. We're using Outlook, of course, as our email server, as our email process. And really the question was, do attorneys have to have Office products? Really, I think the only one that really matters is in the context of Word, or being able to transmit Word documents for the court. That would be the same whether it was virtual or non-virtual. And then Excel, and there are ways to download that into other types of products.
Or like a Google product, you could open an Excel doc in a Google sheet as an example. So I think there are ways to get around having to use Microsoft products. Question about being able to pin the judge and attorneys. Yeah, I think we could do that as hosts. How does the court ensure the public's right to observe jury trials? Fantastic question. We could do a whole another presentation on that, and different courts are doing that differently. Some courts are streaming the proceedings over YouTube, for example. We're typically not streaming in King County. I'm not streaming. I'm just putting everything on audio and video in the courtroom for the public to come in and watch. But I agree, it's an important question. There's an ongoing debate about what is meaningful public access in a pandemic. Is it enough to just say that you can walk into a courtroom? I'm not going to really try and open that can of worms any further. I think I'm just going to turn it over to Judge Williams.
So one of the questions that's been asked is whether or not, how do we ensure the public's right to observe jury trials. And there's two ways that that occurs. We need to be very clear that Zoom and streaming is not a platform that the King County Superior Court is using for purposes of ensuring open courts. Our courtrooms are open. When you're trying a virtual trial, your judge is in the courtroom, usually by themselves, but they are in the courtroom doors are unlocked, the courthouse is unlocked, and the public is free to come and go. And I've actually had observers. Sometimes it's observers from other courts. I've actually had law students and others come in and observe the trial, which is being broadcast into the room, usually through use of either a small monitor or a very big monitor. So the courtroom is open. Now, we also, on a limited basis, and we control the security of the trial through the use of the waiting room. And you can't get into the waiting room unless the judge or the bailiff, or I'm sorry, you can't get into the actual virtual courtroom unless the judge or the bailiff admit you. And that means, so if you have someone who is going to be a witness, we're not going to admit them until we know who they are and that it's time for them to testify. If there's someone who just wants to come and observe, we're not going to admit them until we know who they are. And so Zoom and the platform, the video platform, is not a streaming platform. As you know, in Pierce County, they have live streaming. We actually have a brand new court rule, which you will soon see. It's local General Rule 16, which actually prohibits streaming except under particular circumstances with the judge making particular findings. So let me, again, demonstrate why you should always practice much more than the 10 minutes that I practiced using this platform. And hopefully you are seeing hopefully you're seeing the unit that says, or the slide that says the trial and preparation. Dave, can you confirm that? Judge Keenan, can you confirm that that's okay? Life is good. So let's talk about what happens immediately pre-trial or immediately before. And Judge Keenan walked you through the pre-trial order, but we need you to do some stuff before. And we need you to think about it because so much of the virtual trial, the remote trial, we've pushed a lot of the work before, and there's stuff that you have to do. And this is coming from the judge's heart. Please, please, please. The first time your witness signs in should not be on the day of trial. Please pre-test your witness's connection. Make sure you know what kind of device they're using. Are they using a computer? Are they using a tablet? Are they using a phone? And I've had, and I know Judge Keenan has had, all of those devices. And do they work? Absolutely. But have your witness test with you that connection. Make sure it works, that they've got sufficient either internet or, the reality is in these times we're having to do a lot of MacGyvering. And I can share with you, I was in the middle of a bench trial and I lost my video feed. I still had my audio feed because it was a different internet connection. And what I had to do is MacGyver together a solution where using my laptop, I tethered it to a cell phone, which in turn I used the cell phone signal. We had a countywide internet outage. Tethered it, and so that enabled me to get back into and get the video feed in this bench trial so that the witnesses and the parties could see me and I could see them. Because again, there I'm the fighter of fact. So a lot of times we're having to MacGyver stuff together, and it's okay. You just have to be patient with each other and understand that just as in a live trial, just as in an in-person trial, there's going to be glitches. And the glitches here are going to be different. In many respects, the remote trial is in some respects actually a lot easier. In other respects, it has its own challenges. So please pre-test your witness's connection and pre-test the device that they're going to be on. Prepare your witnesses for the 360. Now, one of the questions we got was, how do we ensure that there's no cheating? Now, which really goes to two different issues. One is the fact that when you're in a remote trial, you, the jurors, and the witness, in terms of your face and the upper body, you're about 3 feet from each other. And trust me, when you're watching that witness and you can see them doing this, you know that there's something going on that shouldn't be going on. And of course, as Judge Keenan said, you're still in court. And so if there's something like that going on and the lawyer or the witness gets caught, it doesn't go down very well. So prep your witnesses for what we call the 360. The 360 is we're watching, the judge is watching, the jurors are watching, opposing counsel is watching, and many of our judges will accommodate what's called the 360. And that's where we want them to take their camera and turn it around because we want to see what's going on around them, or to confirm that they are completely alone or that they're not being handed anything, that there's not anything going on. And I want to mention that specific also in this context, because one of the concerns about both voir dire, but also about witnesses, is the ability to evaluate credibility. And here's the deal. Unlike right now, a COVID trial where you're 40 feet away from the witness and everybody's wearing a mask, as well as your client, you're 3 feet from them, and the jurors can see the micro expressions. And I've actually had jurors comment on the fact, jurors that have participated in both live trials but also virtual trials, that they are better able to judge the credibility of the witnesses. And they're also seeing them in their home environment. We're going to talk about the background and using virtual backgrounds and what's behind you in a minute. The effect of that, though, is this. Jurors report, as do lawyers, and certainly the judges that are trying bench trials, we can better judge the credibility of the witnesses in a remote trial than we can in an in-person trial. I had one colleague put it this way. You know, Matt, it's really rare that I have to see someone from the waist down to be able to figure out their credibility. And now you'll notice, they didn't say they'd never had to, they just said it's rare. And when you stop and you think about it, most of our feedback comes from the upper body. The thing to remember is you're now on the small screen. You're no longer in theater. You're no longer on the big stage. You're on the small screen. And that means your hand gestures, your movement, what you display, it's all on that small screen where the jurors are, wait for it, more focused. That's right, more focused. They are paying more attention than if they were in the courtroom. Now, this is very different than that article that was recently published by the two trial consultants, which you can kind of tell they probably haven't actually participated in a virtual trial. Because here's the deal. When we're in a courtroom, this is our workplace. We're comfortable there, and we focus on what needs to be focused. But for the jurors, and again, I've had jurors report this, and I could absolutely tell you this has been my experience in watching the remote jurors. When the jurors are in the courtroom, that is an alien environment. It's very distracting, and they're worried about how they're going to get home. They're worried about what time they have to come back. They're worried about where they get lunch. When they're in a virtual or a remote trial, they're in a comfortable, safe place, and they're focused, and they can see the exhibits better. And so the reality is we have to be aware that we, the lawyers and the judge, we're managing this small screen. We're managing this universe that we have created for them. So consider, among other things, not only your visuals and your exhibits and how they're going to be displayed, but also consider your and your witnesses' backgrounds. Now, right now you can see my office, which, yeah, I got to tell you, I cleaned it up because it was pretty messy earlier today. And you'll notice that Judge Keenan is currently in his courtroom. We strongly discourage you from using virtual backgrounds. There are some of us that actually prohibit either you or the jurors from using virtual backgrounds because they eat up bandwidth, they cause glitchiness, and they make things look weird. Okay? But so be thinking about what's behind you and what's behind your jurors. And also be thinking about the lighting, because if there is backlighting, then what's going to happen is instead of seeing a face, and by the way, we work with the jurors during voir dire. We want you to be able to see their face. So if somebody's backlit, we tell them to turn their computer so we can see their face. Yeah, but if somebody's backlit, it looks like they're on witness protection. The other piece of preparation we need you to be aware of is this. In addition to uploading your exhibits, if your witness or an opposing witness is going to need an exhibit, you need to make sure that they have it. We're going to talk about that when we get to exhibit handling in a minute. But that means do not count on being able to share the exhibit through Zoom during the trial. Get the exhibit to your witness in advance. So let's talk about what happens at the start of a trial. Now I will tell you, Judge Keenan very graciously has done some really incredible work creating videos of the process, and I'm going to see if I can actually get this video to run.
Good morning, jurors. As you come in, please enable your video. Good morning, juror 9. I'm going to change your screen name to your juror number and send you to the virtual jury room. Just accept that invite when it comes to you. Good morning, juror 3. I'm going to change your screen name to your juror number. Send you to the virtual jury room. So if you can just accept that invite when it comes to you.
Now you can see that Judge Keenan is doing this process. This is something that's normally handled by the bailiff before anybody logs in. And the other thing that you should be aware of is that when you record in Zoom, it doesn't show the actual numbers. Like right now, you should be able to see my name. You should be able to see Judge Keenan's name underneath. When you record, it doesn't show that. But I assure you that when Judge Keenan was recording it, what he was seeing was the person's name or their sign-in, and then he would change the name to reflect the fact that it was juror number 3, juror number 5. And so what that looks like is this. And you can see here, this is one of Judge Keenan's trials. This is one of my trials. When I'm viewing a trial and I take a screenshot, I have open all of what's called the non-video participants. You don't have to. I need to see that because I need to see who's in the room and if somebody speaks, whether or not they should be speaking. But you can see very clearly from Judge Keenan's trial that not only can you see the jurors, and you can see them very clearly, you can see that they're paying attention, and we have the ability to pin and to zoom in on jurors, and we do that. We observe, and we'll talk about that in a second, to make sure that they're paying attention. The judge also has the ability to arrange the order and then transmit it and make that your order. Many of us don't do that. The question was asked earlier, can you put the jurors in order? Can you put the witnesses in order? And yes, if you have the latest version of Zoom, it actually allows you to grab the thumbnail and move it wherever you want. The challenge there is every time the jury leaves the room, they come back in a different order. So every time we boot them out for a sidebar, you have to rearrange it. So heads up on that. But the good news is you can do that, and you can also keep an eye on the jury, or you can have your staff, who is probably your paralegal or your assistant, who's probably one of those non-video participants. They have the ability to zoom in and watch the witness. They can zoom in and watch opposing counsel. They can zoom in and watch the jurors. And if there's an issue or a glitch with a juror, we encourage you to speak up and to let us know that there's a problem. So at the start of the trial, what's going to happen is after the jury enters the room, the judge will swear them in, and then we'll give opening instructions. And the opening instructions here are a little bit different, because not only do we give the standard opening instructions that we want you to submit in Word or in whatever format your judge requests, but now we actually give the logistical, frankly, we give Zoom instructions. And some judges, Judge Keenan was absolutely the pioneer on this, and he has led the charge. Most of us now give PowerPoint or use a PowerPoint back behind the instructions. Because not only are we teaching them about the process of trial, which we would normally do in a live trial, what's going to happen next, we're also teaching them how to use Zoom. And we teach them, among other things, how to hide non-speakers so they don't have a lot of screen clutter, how to just put it on speaker view. We as the judges have the ability to spotlight the witness, so the witness is always on top for all of the participants. And we also will teach them how to adjust the screenshot size. And if you don't know about this, important tip, if you look right here where the arrow is, there's two little lines. If you grab that, you can slide it back and forth, and you can make the exhibit or whatever's being displayed really big or really small. And the same thing with that panel that shows the people on the side. Now you're probably wondering, okay, the juries come in, and remember Judge Keenan put them in the virtual jury room. What does that look like? Well, the virtual jury room is just that. It is a breakout room, and when we put them in there, we do the same thing that we would do if we're putting back into a in-person jury room, where again, there's nobody back there to monitor their behavior. Although I will tell you, both in the live jury rooms and in the in-person, they kind of self-monitor and they report, yeah, they squeal on each other if somebody violates the rules. And we give them the same fear of God instruction that thou shalt not discuss the case with the fellow jurors, with their spouses, with their friends. And here, of course, they've got they're at home. And so we tell them, you can't talk about the case and no one else can be around you. And interestingly enough, they obey. And like I said, when they are in the trial itself, we can tell when they're not paying attention. And your judges are scanning, zooming in, monitoring them. And we encourage you as well. If you think that there's a juror that's not paying attention or is getting sleepy, we encourage you to let us know that. And we also tell them you can't go out and look stuff up. And again, they self-monitor just like they would in a live trial. Now, the advantage that we have found in these kinds of trials, in the remote trials, is that it only takes about 10 seconds to put the jury into the virtual jury room. That's right, about 10 seconds. Now, in a live trial, it's about a 5-minute out, 5-minute back. It's a big deal to boot the jury out of the room. Here, you can boot them out in 10 seconds because we can set it so that they don't have to accept the invitation. They just get removed into the jury room. And same thing, we can close the jury room in about 10 seconds. And so it makes it much easier where we want to have arguments outside the presence of the jury, where there's something you need to say to the judge. It's not as big of a deal. That doesn't mean your judges are necessarily going to be more likely to grant you sidebars and to remove the jury from the room, but it's easier to have those sidebars.
Hey, Judge Williams, can I throw a couple of questions at you from the chat?
Absolutely.
Right, from the Q&A rather. We've gotten a lot of questions, really kind of variations on a theme about informality. Basically, how do you address the informality of this for the jurors? How do you make sure they're not multitasking, that kind of thing? So what do you want to say about that?
Well, and there's two aspects of that. One is the informality. Yes, they're at home. And they're going to be, although candidly, I've observed in in-person jury trials recently, over the last 5 years, very few people dress up as jurors to come to court. But we certainly emphasize, and the instructions that Judge Keenan has drafted, the PowerPoint that he's created that I use, as do many of the others, really emphasize this is court, and you got to take this seriously. And again, we're monitoring them. In terms of multitasking, remember, you and your judge are sitting about 3 feet away from them. So if someone is sitting there doing this, it's possible they're taking notes, and they're allowed to take notes, either handwritten notes or typewritten notes with instructions to destroy them. It's possible, but if there's a question about a juror not paying attention, again, your judge is monitoring it. And I've had instances where I've removed the jury, brought one juror back and just said, are you paying attention? And, they've gotten that kind of sheepish look. And it's like, well, no, Judge, you caught me. It's like, yeah, don't do that. Don't look at you. And you can tell when someone's looking at their phone, you can tell. Because again, you're about 3 feet away. And so periodically your judge will simply remind the jurors in a very stern voice, don't multitask. And that's included in the opening instructions. So is it a concern? Candidly, probably less of a concern than a juror zoning out during your in-person trial, because there, they could be asleep with their eyes open. Here, interestingly enough, once again, they're in a safe environment and they're focused on the screen. And if they're not focused on the screen, you can tell.
And Judge Williams, can I throw one more question at you, because we've gotten 3 questions on this about requesting a 360. And I think what they mean by 360 is just requesting a little look around the environment. Does it need to be arranged in advance? Can it be done at any point during an examination? Do you want to address that?
Ask your judge. Different judges are going to approach it differently. In my courtroom, if you request a 360, usually in the context of a witness, I'm going to ask that you do that outside the presence of the jury. I'm going to ask that you don't, make it a big deal. And if you do make it a big deal in the context of being in front of the jury, that's not generally a happy thing. But generally, if you request the 360, what's going to happen is I'm going to ask them to reach up, grab their camera, turn it around, and to verify. And again, a lot of times, and I can share with you that in one of the trials that I had recently, it was pretty clear that there was someone in the room with the witness, that they weren't necessarily having a conversation, but there was feedback that was being generated. And you could tell that because at every question, they would look like this. And we addressed the issue. And the lawyer was instructed to deal with the client. We took a recess and we dealt with it. Again, I can't really emphasize enough the difference between being 40 feet away from your witness and being 3 feet from their face and being able to see where their eyes are, to see what they're looking at, to see their micro expressions. I have to tell you, I was a slow sell on this, but now I've done, I want to say 25 remote bench trials. And I think Judge Peckman, when she wrote her article, saying is absolutely correct. You can better gauge what's going on with the witness.
One more question, Judge Williams, before we move on. And this one came in over email, and Maggie shared it with us. And it says, if technology savvy is required for participation, why isn't there concern that Zoom juries don't represent a cross section of the community? Aren't we finding that the jurors skew towards younger, more technology savvy juries and fewer older and racially and ethnically diverse juries? I can say that has not been my experience at all, actually. Now, overall, I think that there's a huge problem still with juror diversity in the state of Washington for a number of reasons that don't necessarily have anything to do with technology, but that hasn't been my experience. Judge Williams, do you want to address that at all?
Yeah, actually, and it's a great question, because I think that we start with this idea, the digital divide and the generational divide, the socioeconomic divide, the racial divide. It's the same thing. And what we're finding is, and for those of us that actually track data, it actually has the opposite effect. It has actually increased accessibility. And I think there's a couple of reasons for that. As Judge Keenan said, one of the biggest challenges we have, especially in this economy, is economic. And that deals more with whether or not you have a stable brick and mortar address that you can send a juror summons to. When we get, and normally in each of our jury trials, as Judge Keenan mentioned before, your judge is going to get an initial veneer of about 120 potential jurors. Any juror that has not provided either a phone number, or an email address, we reach out to, and our bailiffs take time to do that and to call them up. And I've had jurors that don't have an email address, and we make alternative arrangements for them to participate. The other thing, again, is in the context of the fully virtual trial where everyone's on Zoom, they don't necessarily have to be in their home. We could allow them to come down, and we've set up in both the MRJC Law Library and in the downtown King County Library at the King County Courthouse, we've set up workspaces, we've yet to have to use them, where if a juror wanted to do that, they could come to the courthouse and we provide them with the device. The other thing we're finding is this, again, the generational issue. I actually had a trial where that was raised, at which point, because remember, from the jury questionnaire, we have a huge volume of demographic data. My response to that was just to hold up the actual demographic data for the responses and the number of people that were requesting hardships due to technology issues. Yeah, it wasn't generational. Interestingly enough, in these times, the biggest hardship deals with the fact that the schools aren't open and that people don't have the ability, they can't focus because they've got kids at home. And that really is a much greater hardship issue. The other issue is, well, what about jurors that, they're really uncomfortable with Zoom? Well, one, that's one of the reasons why, and thank you, Judge Keenan, for drafting these instructions where we walk them through. I've even had situations where I've held up my personal iPad and showed them what buttons to push, so that the jurors are comfortable, at least in knowing how to get in and observe things. And point blank, Zoom, it's a really ubiquitous, I love that word, it's a really ubiquitous platform. It's easy to use, and more, there are very few people that don't use it. We've also found that in every set of jurors, and I can tell you the jury that I have deliberating right now, there is always 4 or 5 just super techie, they're entirely into it. And there's always a couple that they're really struggling and they're, trying to figure out what buttons to push. So when they ask me for help, I can give them, I can't give you, but I can give them limited support. But it's interesting, they help each other, and they help each other through those technology glitches. So if I may, I'm going to talk about jury questions. Because remember, in civil trials, as you guys all know, if you have a witness on the stand, whether it's a remote witness or a live witness, obviously this doesn't happen with video deaths, but if you have a witness on the stand, the jury gets to ask questions. Well, normally we just pass out the paper, they hand it back. How does that work here? And here, what happens is, and there's a number of ways of skinning the cat. Some judges have the jurors send an email to the bailiff with the questions they have. Some judges actually have sent them a link to an MS Forms questionnaire, just like the one that they filled out before the trial. Judge Keenan and I think fall in the category of, once they're in Zoom, we don't want them going anywhere else. And we have them use the chat function. And in our jury opening instructions, we not only teach them how to use it, we practice it with them. And so what happens within Zoom, there's the ability of the host, the judge, to have the juror send the question or any question or any chat only to the judge. So we open that up, and then we have them, and then we open up the jury room, and after the witness is completed, we say, okay, I've opened up the jury room. If you have a question, type it into the chat to me. And then after you're done, go into the jury room. And when everybody leaves the room, we know we've got all the questions, at which point we then put those questions, we copy those questions into a form, which we show to the juror, show to counsel. And if I can get this video to play, I have no confidence in my ability to do so, but Judge Keenan, once again, has actually recorded how this works.
Okay, members of the jury, I think that's all the questions then from the jury to this witness. I'm going to send you to the virtual jury room while I discuss those questions with the lawyers, and we'll bring you back in a few minutes. I'm opening the virtual jury room now.
You'll notice that the jurors slowly vanish out of the room. When the questions are done, then we know that the jurors have finished, or when they're out of the room, we know that we have all their questions. We copy them into, at least I copy them in, and I think many of our judges do the same. We copy them into a format. We then screen share and we show you the questions, and we talk about, should the question be asked, and what format it should be asked. And we have Judge Keenan and I have collaborated and built a form that allows our judges to be able to do that.
Okay, member.
So let's transition now to the thing that I know that you're all kind of wondering about, is exhibits. And yeah, exhibits are stressful when you're in trial. Remember when you were in law school and before your first, 5th, 25th, 60th, 100th trial, and somebody made the objection, lack of foundation, and remember how you stressed about getting your exhibits in? Well, it's stressful in person. Weirdly enough, in this environment, it's actually a little bit easier. It's just different. Now, the first thing you have to remember is if an exhibit has been uploaded, and we give you, as Judge Keenan said, it's built into the pretrial order. There's a template that shows you, here's the format by which you upload the exhibit. When you do that, just like in the joint statement of, when you produce the joint statement of evidence, and it should track, the joint statement of evidence and the exhibits that you upload should track, it has been marked. And the clerk has created a folder that you have access to that has all of the exhibits, and those are the original exhibits that are in that share file folder. Those are the exhibits that go up to the Court of Appeals. And so the exhibit has already been marked, so you don't have to do that anymore. And so we don't have to show it to opposing counsel because they have access to share file. You don't have to ask to approach the witness because you're 3 feet away from them. You don't have to hand it to the witness in the traditional sense. But what you do have to do is you have to direct the witness to the exhibit number. You do not screen share it, not at this point because it hasn't been admitted, and it can't be shown to the jury until it's admitted. Now, a lot of times the lawyers will work together, and that's why that joint statement of evidence, what's admitted, what's not, is really important. But sometimes there's argument as to whether or not foundation can be laid, what, there may be relevance issues, hearsay issues, authentication issues, evidence issues. And so sometimes you have to lay foundation through the witness. And this is why it's really important that your witnesses have received and they have access to a copy. And again, there's lots of ways of skinning that cat. We're going to talk about those in just a second. But again, the process here is you direct the witness to the exhibit. They have their copy. They look at it. You lay your foundation. You offer it. And after it's admitted, you ask to publish. And how do you publish? Well, you screen share. But you don't screen share from, this is what we've learned the hard way, you don't screen share from our share file system. Why? Well, as cool as it is, it's really clunky. So you will have your own copy, which needs to be exactly the same as the one that's been uploaded. You'll have your own copy on your system, and you will screen share from your computer. The question was asked earlier, does the court control that? Yes, in the sense that we tell you it's permissible screen share. We're not the ones doing the screen sharing. You are. We don't provide that support. And so if you're uncomfortable with that, we strongly encourage you, practice, practice, practice. Do it, set up a Zoom meeting and just practice with your staff. So the exhibit dance is a little bit different. And by the way, when you upload it, our chief presiding civil judge, as well as the clerk's office, have asked, please do not include argumentative names. So you're going to upload it. The protocol is exhibit number X dash, and then a short neutral description of the exhibit. In a pretrial order, there's also an explanation of how you upload depositions. More about depositions in a second. But remember I said that there's a number of different ways of skinning a cat of making sure the witness has one. One, you just send them. You send them a hard copy. You can send them a little notebook before the trial. It requires some thought, but you can do that. Two, you can email it to them. So they can just be looking at it on a computer. And candidly, that's the most common way in which the witnesses are looking at the exhibit. Or you could email it to them right then during the trial, or have it emailed to them by opposing counsel if it's on cross-examination. There's actually even a feature inside of Zoom. It's called the file share feature, which is what you see displayed there mid-screen. It's part of the chat function where you can actually send through chat only to that witness the exhibit. Doesn't go to everybody, only goes to that witness. And again, requires some practice. But if you're concerned about not being able to transmit an exhibit to the witness beforehand, that's another way. The least favorable way of doing it, and you can expect your judge will ultimately lose patience with you if you rely on this exclusively, is ask for a sidebar. We boot the jury out of the room, You lay foundation, admit it, and then you bring the jury back in. A lot of reasons why that's less than optimal, not the least of which is the resources and the time that you would have to essentially re-ask questions so that the jury understands the significance of it. This again is an area where just some advanced thought about your direct examination or your cross-examination is really important. But now, what about depositions and impeachment exhibits? Well, first off, you do not show them to the witness through screen share, unless the witness either denies it, if it's impeachment, or doesn't remember, and you have to move to past recollection recorded. But even then, in past recollection recorded, if you're a refreshing witness, you don't show the jury the exhibit or the deposition. When we use depositions, remember there is a copy of the deposition that has been uploaded into ShareFile. You don't display that. You have your own copy in the event the witness denies that they actually said the thing. And only after the witness denies that they said the thing, you can then ask to publish to the jury the deposition excerpt, that page in which you have quoted when you ask the question at the end of your impeachment litany. Did I read that correctly?
Hey, Judge Williams, can I jump in with a question that sort of on this topic? And somebody just asked, what if you want to show an excerpt of a party's video deposition? And I know there's an answer to this question, and so I'll just turn it back to you.
You'd handle it exactly the way you would handle it in court. If it's something that you would, again, you've asked them the question, you've done the first, what we call the verbal, and generally we confirm, credit, confront. When we get to confrontation, we'll say something like, and in your deposition, you said that the moon was green. And the witness goes, no, I didn't say that. Well, let's take a look. Okay, and you would clear that with your judge in advance, and then you would screen share. But the witness has to deny the statement first. And that's part of the standard litany of impeachment, just like what you would do if you were live in court. Same thing, and it works exactly the same way in the remote trial. Now, the question came up earlier, okay, what about the original sealed copy of the depositions? Are those obsolete? Absolutely not. The thing that you have to remember is that when you were in in-person trials, you would come in, you bring in your box of deps, you hand them to the clerk could stamp them in, and then they'd sit there until you move to publish the dep. And as we know, in this context, that word publish doesn't mean publish it to the jury. It just means that that's the key that the clerk would then slit it open and hand up the original to the judge so the judge can read along and make sure you're not making stuff up. Well, in this remote trial context, the clerk's not in the courtroom. It's just the judge. But the judge has the box, and you haven't delivered the box of original depositions to the clerk's office. You've had it delivered to the judge's mail room. So the judge has the box of the original deps. And when you say, Judge, I move to publish the deposition of John Smith taken on December 28th, that means the judge will flip through, pull out the deposition, the judge will open it up, and then the clerk will come up later and stamp it in so it becomes part of the official record. And so that's, again, something that's a little bit different, but the process is still, in the context of the steps that you go through, it's still pretty much the same. Just have to bear in mind that the parties may not be in the same place at the same time.
Judge Williams, can I jump in? Just, I think, a clarifying question on this use of video deposition excerpts during the trial. So it says, Judge Williams, yes, for impeachment, but a deposition of a party can be used for any purpose. So do we just need to clear that with the court? I think the short answer to that is yes, and you just play it through the Zoom. You could, I've done this in trials.
It's, again, sometimes we can get kind of wrapped around the idea of, oh my gosh, it's technology. But you know what? Pretty much everything, the general idea stuff works the same. It's just a slightly different media. So again, you clear that with the judge. And I actually had my last virtual or remote jury trial was a lot of video depositions of the parties. There was 30v6, there were experts. And I want to say probably about 30% of the plaintiff's case was, maybe even more, was video depositions. And again, we just talked it through. Again, when you're working with video depositions, and I know many of you have, but just be aware when you're working with video depositions, you need to be aware one of the pretrial processes are the deposition designations. For those of you that do asbestos work, you know that what that is, because those are very common. And for those of you that have done this, you know that part of that means you have to give the judge in advance the page and line, along with the deposition, the hard copy of the deposition, or a copy of the deposition, the page and line that you want to admit. The other side has a chance to object. The judge will make an advanced ruling as to whether or not it's admissible. So you don't just get to say, hey, I took this deposition. You have to submit the page and line in advance so that the video can be edited so that the objections can be dealt with. And then the judge will make those advanced rulings, and then you just play the video to the court. I hope that answers that question. So you've tried your case, you presented your evidence, final instructions. How do they work? Well, got to tell you, they work exactly the same. You submit your proposed instructions. There's 3 to 4 additional instructions that we give at the end, and we've modified the instructions a bit to reflect that the media is different. And again, thank you, Judge Keenan. He and I actually spent a lot of time collaborating on those instructions to make sure that the jury understood how stuff was going to work. And the process of the verdict form works a little bit differently. And again, I know that you're thinking to yourself, well, wait a minute, we're sticking the jury in this virtual jury room. How do we know they're alone? How do we know that they're going to behave? And the short answer to that is the same way we know that when we stick them back into a jury room, they're going to behave. We tell them to, and they self-monitor. Yeah, they rat each other out if somebody's not behaving. And we give them very strict orders about being alone. And we also monitor them, not in the sense that we monitor what's going on in the jury room, because once we put them into the jury room, then we can't see them. But the bailiff is sitting in the virtual courtroom. And what she has in front of you is what you can see now on your screen, which is this list that shows her that the jurors are present in the courtroom, that they're deliberating. And if someone for some reason drops off, and again, we give them instructions, what to do if there's a technology glitch. And by the way, during the course of your virtual trial, there will be a technology glitch. You will lose your internet, a juror will lose an internet. And we actually use that as a teaching moment with humor. And we say, okay, and this, by the way, is exactly what happens if when you're deliberating, you just stop. And we just stop. And the jurors are instructed just to stop. And we can tell, or rather the bailiff can tell when a juror has disconnected, because that little green light, it changes from a little green light to what you see here on the slide. Next thing that you're wanting to know is, well, okay, now wait a minute. How do they get the jury instructions and the exhibits? Do we box them up and do we print them out and mail them to each jury? Do we make them come down to the courthouse? And the answer is generally no. In fact, no. The way it works is that each time an exhibit is admitted during your trial, the clerk is creating and has created a special folder that belongs only to the jury. And that folder, every time an exhibit is admitted, that exhibit or a copy of that exhibit is placed in that folder. After the trial has completed and the jury has been instructed, each juror receives an emailed copy of the verdict form and of the jury instructions. They have their very own copy, and they get access to that folder. Before we send them that link to the folder, your judge and your bailiff will send it to you and say, hey, look it over. Is there any issue in this? I can tell you in my last trial, we sent it out and one of the lawyers said, hey, wait a minute, there's these 2 exhibits that were admitted. Well, we went back and actually they turned out that they weren't. They had not actually been offered. That lawyer thought that they had been, but when the clerk actually went back and listened to the record, they weren't, and the clerk had got it right. Don't be overly surprised if that's the case, because our clerks are very good at this, and they keep track. In fact, my clerk, and in conjunction with Judge Keenan's clerk, actually wrote a manual that helps DJA understand and the clerks understand how to transmit this exhibit. or how to transmit that, first to the bailiff, to you, so you can double check it, and then to the jurors. The jurors are instructed in the final instructions, they can only look at the exhibits during deliberations. And there's actually, the way that folder is set up, the clerk has put bookends on the time frames in which they can look at it, and we can go back and we can tell, and we can terminate their access once the trial is completed. The folder does not allow them to download the exhibits. They can view them, but they can't download them. And they're given express instructions that they are not to copy, try to print. They can't use a snippet tool. And we're very specific in instructions. And so that once we're done, they don't continue to have any copies of the exhibits. The exhibits, though, are part of the official record, which on any appeal would go up. The jurors are also instructed at the end of the trial to destroy their notes, and that's included within the jury instructions. Now, the last thing you're thinking about is, okay, fine, we've done all this. What do we do about the verdict? Because they're not in the courtroom, and how does this work, and who signs it? Well, when they reach a verdict, they notify the bailiff, either by the presiding juror going into the jury room, asking the presiding bailiff to come into the jury room, or they'll simply email the bailiff the verdict form that is in which the presiding juror has typed their name along with the result. They filled out it's a Word, generally a Word document. Although we've actually had presiding jurors have printed it out, handwritten it, taken a photograph of it on their phone and sent it in. So again, lots of ways to skin this cat. So the presiding juror will send the verdict to the bailiff. The judge brings, with you in the room, brings all of the jurors back into the virtual courtroom and takes the verdict just like they would, with, of course, the exception if they're just type the name. We have adopted what Judge Zilli from the Federal District Court, the process that he created. And so generally, if we don't actually have a wet signed version of it, what we'll do is that we will poll we won't ask you, we're just going to poll every member of the jury, whether or not that's the verdict of the jury and whether or not it's theirs. And then at the end of that, your judge will ask the presiding juror if the judge has their permission to sign the verdict form on their behalf. And they do. And at the end of the day, that's what gets filed. So that's kind of the overview of trial. I have to share with you, every lawyer that hasn't done one is generally sitting there thinking, because we have 2 centuries of a tradition of in-person advocacy. This is what we're used to. Every lawyer that hasn't done one of these approaches it understandably with a degree of trepidation and believing that this is this huge hurdle to overcome. Every lawyer that I've talked with that has done one thinks it's better than sliced bread. One of the more interesting comments that I recently received from 2 lawyers on opposite side of the case, and a comparable comment from a juror in that case, was that they found that this forum tended to level the playing field as it related to gender issues, because either it's because there's less, people have got to take turns when you speak, and your judge will enforce that. Or as one of the lawyers said to me, and this is a direct quote, and so I just want you to know this isn't coming from me, this is coming from this lawyer. She said, normally when I'm in court, I'm worrying that people are going to judge me how I'm dressed and about my shoes. And I didn't feel that way here. And I didn't feel like I was being bullied, which, was an interesting comment. And I just offer that to you. But again, this process is going to, when you first start it, it's going to seem overwhelming. But as Judge Rogoff said, he tried our very first case involving virtual voir dire. You just get started. You just do it. And yeah, there's going to be glitches and problems. And you approach it with humor and civility. And not only will you get through it, by the time you're done, you're going to find, okay, maybe it's not something you want to be a part of your regular lives. Although, as Judge Cahan recently said, this is probably something that's not going to go away. This probably in 5 years, this will not only be our new normal, this will be probably the mainstream of how jury trials take place. But the reality is, it's not only doable, if you're willing to understand that you're dealing with a small screen, it's a different skill set. You not only can succeed as much as you did before, you can have even greater success.
And I know I get a lot of questions about, well, don't you need a fancy setup for all of this? And this is really going to vary from jurisdiction to jurisdiction. Understand that there are judges around the state that are still trying to figure this out. Judge Williams and I are still trying to figure some of this out. But I can tell you the last trial that I ran from this laptop, and I used a desk lamp for illumination. And I have a better camera now, and I have a ring light. But at the time, I just had a laptop and a desk lamp, and I made that work. That doesn't mean, I don't mean to give short shrift to some of the technology access issues, especially in rural areas. There are any number of issues. So your experience may vary from jurisdiction to jurisdiction. Maggie asked that we thank you all for participating. Judge Williams, is there anything you want to say before we go?
No, just that, at the end of the day, be patient. And I did want to note that a lot of times the solutions we come up with during trial, I'm not kidding, we're MacGyvering stuff together. We're inventing the solutions we go. And it's okay to admit to the court and to the jurors that, you know what, we're new to this. It's okay. In fact, if anything, it builds that empathy bond. Thanks for everybody. Thanks to everybody. And I have to say, for those of you that have actually done one of these trials or participated in virtual voir dire, we thank you, because without your hard work, and I want to especially call out the good work that Carl Forsberg and that Ray Umlauf gave to us early in this process, along with other with members of WDTL, but also of Wasatch. Early in this process, as we're developing and brainstorming, and even during the development of the training programs, which you'll see the other one on the WDTL on jury selection, even during the development of that, we were figuring stuff out as to what worked and what didn't. So thank you all. And thanks for your hard work and your patience and civility.
Thanks, everybody.